So the 1976 Copyright Act provided for a broad performance right that applies regardless of whether a performance is a profit or not. But Section 110 of the Copyright Act provides a number of exemptions applying for certain nonprofit, educational, charitable uses that Congress believed to be in the public interest. They wanted to limit the copyright owner in order to benefit the public. The first exemption is in Section 110(1), and it's the face-to-face teaching activities. By instructors or pupils in the course of face-to-face teaching activities of a nonprofit educational institution in a classroom or similar place devoted to instruction. For example, so if a band meets, if there's a Belmont band and they meet for class, that counts under face-to-face teaching activities because they're face-to-face and it's for instructional purposes. But if they were to go perform that music in an auditorium, that would not count under face-to-face teaching activities because it's not in the classroom, etc. Congress passed the Technology, Education, and Copyright Harmonization Act to amend the performance and display exemptions of the Copyright Act in order to allow for educational use of copyrighted material in digital form in certain circumstances. The TEACH Act is extremely important because distance education has become very common with many universities offering online courses. The next exemption is religious services, and it's for performance of a non-dramatic literary of musical works of a religious nature. So it has to be in a place of worship and for a religious purpose. So if there is a performance of a secular dramatic work, it is not exempt. The next exemption is for certain nonprofit performances of non-dramatic literary or musical works. And there's only 4 conditions, but it can get kind of confusing when deciding whether or not a copyright owner can have an objection. If there's an admission fee, they can usually object. And an example of this is a benefit concert. The next exemption is the homestyle receiving apparatus exemption, and it provides an exemption for businesses who play radio or television broadcasts on a standard radio or television equipment. So the National Restaurant Association began lobbying Congress to change the homestyle, claiming it was too difficult to interpret, but probably because they did not want to have to pay more license fees to play the music. And so they created the Fairness in Music Licensing Act to provide a much broader exemption than the homestyle exemption. This means that certain businesses that perform music received from licensed radio, television, cable, and the satellite broadcasts are exempt from having to obtain permission to publicly perform music in their establishment. The next exemption is retail record sales. It provides an exemption for performances of a non-dramatic musical work in a connection with sale of phonorecords or sheet music that embody the works. So basically, stores that sell recordings are allowed to play them in order to promote sales. The next exemption is non-commercial broadcasting. So although public broadcasters are not exempt from performance licensing, Section 118 of the Copyright Act provides for a compulsory license, permitting the performance of published non-dramatic musical works. The rationale for this compulsory license is that public broadcasters should have easy access to copyrighted works. In the sound recording and performance right, Section 114A of the Copyright Act provides that the exclusive rights of the owner of the copyright in a sound recording do not include any right of performance under Section 106(4). So the attempt to extend the Section 106(4) public performance right to sound recording have been unsuccessful due to a number of problems listed right here. So the Digital Performance Right in Sound Recordings Act granted a limited public performance right for sound recordings. The DPRSRA made 2 basic changes. They added a new exclusive right of public performance for sound recordings and expanded the compulsory mechanical license provision to include the reproduction and distribution of musical compositions in the digital format. The Digital Millennium Copyright Act contains some provisions amending the DPR-SRA, some of which extended the digital performance right to the practice of webcasting, but the DPR-SRA amended the list of exclusive rights, stating that the copyright owners of sound recordings shall have the exclusive right to perform the copyrighted work publicly by means of a digital audio transmission. The DPR-SRA classifies digital audio transmissions into 3 categories to determine whether a license is required to publicly perform the sound recording, and if so, what type of license is needed.